Okay, our next case is Goodluck versus John Wims, Commissioner of Education.
Yes, thank you, Your Honor. May it please the Court, I'm Mark Kelly for the appellant, and I'd like to reserve 3 minutes of my time. The issue here is whether the appellant's allegations were sufficient to entitle him to an evidentiary hearing. He raised fact issues regarding the sufficiency of service of the administrative complaint in the original proceeding, whether personal service could not have been had on him, and whether the commissioner made a diligent search that would have justified the resort to constructive service by publication. Diligent search as defined in the Reich against Department of Health case, Canzaniero versus Canzaniero, and Levinson against McCarty. It's well settled that constructive service by publication requires strict compliance with the statutory guidelines and is strictly construed in favor of...
Couldn't the EPC serve him at the address he gave, and wouldn't that alone be good? Every certificated school teacher in Florida is required to keep a current address by law with the EPC.
Well, but they didn't do that.
They didn't do that?
No. They didn't serve him at his last known address, and they never made personal service on him.
Are you saying that the service that was originally made was not made to the address that the teacher had on file with the EPC?
That's not what the record shows, and that's certainly not what his allegation is in this case, Your Honor. It's our position that he was never properly served with the original complaint. Otherwise, there would have been no need to go through the alternative procedure of substitutive or constructive service. And I think the allegation is that he was never properly served. I think that's what's before the court here.
But whether he was properly served, I guess, assuming we're going to reach that question, and that's debatable, but is an issue of law. But I guess I understood that it was sent to the address of record and simply not picked up, and then he claimed he never received it.
No. That was a previous letter. There's no evidence in this record that the administrative complaint itself was ever served by certified mail. There was a previous letter that was sent to Mr. Goodluck that wasn't the complaint, that somehow did not get claimed. It wasn't refused, but it didn't get claimed.
Well, would you concede that personal service is an issue that can be waived?
Certainly.
Now, this defect, he did get the final order.
Yes, but the case law that we've cited in our brief shows that if he wasn't properly served as required by statute, whether he had notice of the final order at a few days...
What I'm saying is he could have appealed the final order, but didn't.
Well, again, we've got a disputed issue of fact as to whether he had notice, and we think that the case law...
Let's say he didn't. Let's say it's an accepted fact he didn't have notice. He gets the order, and I guess for the first time says, wait a second, I just got a penalty here I wasn't aware of because I didn't get this complaint. And then he takes no action. Is that not a waiver of the personal service?
No, because personal service was not effected. I think it can be waived by a voluntary appearance in the case, but it can't be waived just because you got a piece of paper that says there's a case. And the case we've cited in our brief, the Bedford computer case, I think addresses that point, that if the actual attempt to serve process was defective, then notice of the proceedings is immaterial, and it can't be, that defect is not cured by the mere fact that the defendant in the case had notice.
Well, I know there's a lot of case law that says that it's a void and it can be subject to a motion to vacate. I understand all that, but those cases usually are cases that occur after the time for filing an appeal is gone, and in this case, your client got the order in time to appeal but simply didn't do it. And I guess you're saying that doesn't make any difference, right?
I'm saying, first, it doesn't make any difference under the case law we cite, but secondly, it's a disputed issue of fact. He disputes that he got the order, and there's never been an evidentiary hearing. So
okay, now I'm being correct on this point. You're saying he disputes that he ever got the order itself, not just the complaint.
Right, the order, absolutely. Okay. So both issues are still alive. So if in fact he was never properly served, then I think the law is clear that there is no personal jurisdiction over him. And what that does is, unless he is somehow precluded from asserting the argument, that means that the original order was void and it should be set aside. What we're asking the court to do here is, because there are disputed issues of fact regarding whether personal jurisdiction was ever achieved, that the court stay the final order that we've appealed in this case and remand for an evidentiary hearing on his claims, and that in addition, additional relief be awarded in the form of a stay of the original final order pending those proceedings. If after an evidentiary hearing, if it's concluded that there never was personal jurisdiction in the first case, then of course both orders, I think, would be rendered void and without prejudice to the commissioner filing a subsequent administrative complaint on the same allegations. If following an evidentiary hearing it is shown that there was personal jurisdiction, then I think both orders should be reinstated, because if he had jurisdiction, then of course he's waived any arguments he's had by not timely appealing the original final order. Now, the commissioner also raises an issue in this case as to whether judicial estoppel or law of the case bars the relief that the appellant seeks here. I think the case law that we've cited shows that because the prior appeal was not a timely appeal from the final order itself, but was an appeal taken from a subsequent interlocutory order, that not only could the appellant not successfully raise issues in that proceeding relative to the merits, but that the court actually would have lacked jurisdiction to entertain arguments.
He filed a motion to vacate and to redo the order or something to that effect, right?
Correct.
Claiming that he was never served.
Right.
That was denied.
Yes.
He appealed that.
Yes.
And this court, per curiam, affirmed
Yes.
that. So why does that not stand for the proposition? Why does that not resolve that issue?
Because of the case law that we've cited that holds that where the time to appeal the original determination on the merits has expired, as is the case here, and some subsequent interlocutory order is entered, the court is and that appeal is that order is appealed. The reviewing court is confined to the question that's presented on the appeal from that order, which is did they or did they not abuse their discretion by refusing to issue another order? And of course, there's no rule. This is not a situation like Rule 540B. There's no administrative analogy that I know of. It's just there is some case law out there that an administrative agency has discretion to reissue an order if it wants to.
But if they agreed with you their client had not been served, there'd be no discretion in the matter at all, that the order would be void and they'd be obligated to vacate it, right?
Well, it's our position that that issue was not necessarily presented by the appeal from the interlocutory order that was taken. At least that's what the case law indicates to us, and that the court really couldn't have gone beyond the limited issue that was raised there, because to do so would extend the time indefinitely for filing an appeal from the original order. So the crux of the case is that if as we contend, there was no proper service or process made on the appellant, then we think he should get his day in court to try to show that. And if he can convince
Counsel, in regards to the law of the case doctrine and or the doctrine of res judicata, do you agree that we have both the same parties in the first appeal as we had in the third appeal? Yes, sir. Do you also agree that the issues were raised in the first appeal?
We did, yes. Yes, we did raise those issues in the first appeal. We've agreed with that. Okay. But the court didn't address them. And what our position is on that is that it was futile for us to raise them because it was not within the court's jurisdiction. But you do agree that the court denied you any relief in the first appeal? Oh, absolutely. If there's no further questions, I'll reserve the rest of my time.
Okay. Thank you.
Good afternoon. Charles Whitelock on behalf of the Commissioner. Mr. Kelly remarked he wanted his client to have a day in court. On December 20th, 2000, EPC issued its final order. The record shows that Mr. Kelly's client gave a sworn statement on January 23rd, 6 years ago today, that he had received the final order and the letter of reprimand. They
Mr. Kelly
turned around
says
and
Mr. Kelly says that's a disputed issue of fact.
I don't believe it's ever been disputed. And
He
we
just-
provide
he just-
sworn
He
testimony.
just said 5 minutes ago that it's a disputed issue. I mean, either it is or it isn't.
You're right.
Do you agree?
He
You're
did
saying-
say that, Your Honor. I'm
You're
not
saying his client has admitted that he got this.
Oh, yes, sir.
Okay.
He did get it. There's not an issue that was presented both to the EPC and to Judge Green in the circuit court case. There's not an issue on that. Notwithstanding that, let's just assume for a moment that he didn't get it. Let's just assume for a moment. On April 24th, I take it back, on May 7th of 2001, he filed a motion for rehearing with the EPC. It was denied. Took no appeal of that. Then on January 15, 2000, the EPC, according to them, issued a final order and a probation violation. Actually, it was only a notice of a probation violation. EPC never issued anything, but even if they did, he's appealed that here and appealed it in the last appeal, but he never appealed it at that time, back in 2002. And then he went ahead and filed a lawsuit in Broward County back on April 24th of 2002. At that point in time, Judge Green, 4 months later, issued an order directing it. It was at this time, Judge Green told him, he cited a case that said there was an administrative rule that prevented a motion for rehearing. I think it was probably correct at the time the case was issued, not correct in today's standards. But nonetheless, he suggested that Mr. Goodluck should go ahead and file a petition to vacate, which they did. And they filed that in September 12, 2002. And I might add, the EPC issued an order denying it. The reason they did that is because I asked them to, because it put a finality to the process so that they could finally appeal it, not complain anymore. They didn't have an opportunity or an avenue to appeal. He did appeal. I have the tape. You want to listen to it, or just see whatever it is? The last argument, it's verbatim of what is here today. We've argued the same cases, the same law. We've wasted your time, my client's money, and everybody's effort in this case. This case has been decided. There comes a time when enough's enough, when the ball game is over. Somebody scores the last run, and the game's over with. This court issued a PCA, and as we cited in our case law, it's either law of the case, which I think is what is applicable here, is law of the case. But if not, it's res judicata. But in either instance, it's judicial estoppel. They've had an opportunity to litigate these facts and issues, and it was to their detriment. So, to me, the case is over. Unless Your Honors have any other questions, I have not. The only one thing I wanted to comment on is Mr. Keller remarked that that was an issue. And if you read, I think, page 1 of his reply brief as to when Mr. Goodluck received that, and I know what he commented. If you look at page 1 of his reply brief, you'll see that he thought that was inconsequential in this argument. It had no, because only the lack of proper service was the issue for this court to consider, and whether or not Mr. Goodluck ever received actual notice of the final order is immaterial. But at one point in time, he did receive notice, and he did appeal. And unfortunately for Mr. Goodluck, he lost to appeal.
Let me ask you just one question, and I understand whether he received the original complaint or not is an issue that's not necessarily in play in this appeal. I understand your argument on that, but just for my own edification here, for whatever it may be worth, did the department send the administrative complaint to him by certified mail to the address that he gave them that they had on file?
Yes, sir.
Okay.
Thank you.
All right, thank you.
Again, Your Honor, I'll stand by the representation that we don't agree with that. There's a disputed fact issue about that. And, of course, there's never been an evidentiary hearing at any stage in this case. The EPC never decided the motion for reconsideration because it was never placed before them. We asked the EPC to reconsider this case shortly after Mr. Goodluck finally did get notice of the final order. Their counsel told us that they had no jurisdiction, so it was never brought before the EPC, and no order was ever entered. Therefore, there was nothing for Mr. Goodluck to appeal Instead, because we were looking for a remedy somewhere, we went to the circuit court. The circuit court told us, well, I can't help you because you haven't exhausted your administrative remedies, because I found some cases that say that, you know, you can at any time go back to an administrative agency and ask them to reissue a final order for purposes of appeal. We took the judge up on his suggestion and did that. We didn't get anywhere because, well, I don't know if this is in the record, but what happened was then counsel for the EPC said, well, he was served by publication, thinking that the service by publication had been valid. And of course, we contend that it wasn't because it was in the wrong county. But in any event, that was the order that was appealed. That's how we got to this court. So if there are any other questions, I'll be glad to answer them. Otherwise, that's all.
Okay, thank you, Mr. Kelly. Thank you both.